What is the unique origin of sui generis database rights in the EU? Imagine a world where creating a database isn't enough to protect your hard work. You might think copyright covers everything, but that's not always the case. This is where sui generis database rights come into play, and they have a very special origin story. Back in the early 1990s, the European Union saw that traditional copyright law didn't fully protect databases. Copyright only protects original works like books or music, but not the data itself or the effort behind gathering it. Many companies and researchers were worried their investments in collecting and verifying data weren't protected enough. So, the EU decided to create a new kind of protection. This led to the adoption of the Directive 96/9/EC, also called the Database Directive, on March 11, 1996. This directive introduced a new legal right called sui generis database rights. The term sui generis means of its own kind, highlighting how different it is from copyright. This right is based on the idea of sweat of the brow, meaning it protects databases where a lot of effort, time, and resources have been spent in obtaining, verifying, or presenting the data. Unlike copyright, it doesn't require the database to be original in the artistic sense. Instead, it focuses on the effort and investment made. This unique origin story is tied to the need for protecting data-driven investments, especially in the digital age. It was designed to encourage the creation of large, valuable databases by giving creators a legal tool to stop others from extracting or reusing their data without permission. In the context of technology law and digital content rights, this protection is especially important for artificial intelligence systems. These systems often depend on huge datasets for training and operation. Without sui generis rights, companies might hesitate to share or invest in data collection, fearing loss of control or profits. The EU's approach has influenced other parts of the world, although not all regions have adopted similar protections. For example, the United States relies more on copyright and contract law to protect databases, which makes the EU's sui generis rights quite unique. In summary, the origin of sui generis database rights in the EU comes from recognizing that traditional copyright law wasn't enough to protect the effort and resources behind large datasets. It was created to fill that gap and support innovation and investment in the digital economy.